Welcome back to the video lecture on East Asia's cultural influence on the law of the sea. This time, we are speak on a bit different aspects of the cultural influence of East Asia in a case of a progressive lawsuit filed by victims of forced labor and the lawsuit in relation to the Japanese military sexual slavery in Korea. The decision raised great attention in that it was a ruling which assertively developed, unfold, deploy legal principles to relieve victims of the military sexual slavery and forced labor, the two most notable national war crimes that originated from the Japanese occupation and Japanese colonial period. In 2012, the two highest courts of Korea, the Supreme Court and Constitutional Court, issued assertive rulings on the Korea-Japan's history. At the time, the Supreme Court ruling on the forced labor case was in which the victims of the illegal, the forced labor, the seeking compensation against the Japanese defense manufacturers, the rooted in the wartime manufacturers, which forced labor in produce military supplies during the Japanese occupation, and the key issues of the case involved whether the victims' claims rights were extinguished by Korea-Japan, the settlement agreement of the 1965. We call this one as simply the claims agreement. The Supreme Court, as contrary to the lower court decision, which dismissed the victims' claims on the ground the same lawsuit was already proceeded in the Japanese court, has reversed and remanded the case based on the refusing to recognize the judgment of the Japanese court when contrary to the spirit of the Korean Constitution, the victims' personal damages claim were not extinguished by the claims agreement and by acknowledging the liability of the Japanese manufacturers for damage. The court, which the case was remanded, acknowledged the liability of Japanese manufacturers in accordance with the Supreme Court ruling by ordering the Japanese manufacturers to compensate the plaintiff, the victim of the forced labor, 100 million won each and around 80 million won. This is around the 80,000 US dollars and 65,000 US dollars to each of the victims respectively. However, the Japanese manufacturers objected to the decision and filed appeal against the Supreme Court, which the Supreme Court dismissed through retrial affirmed the compensation award for the plaintiff. Since then, despite the Supreme Court ruling, the Japanese manufacturer failed to proceed with the compensation order, which initiated the seize of the domestic assets owned by the Mitsubishi Heavy Industries, as the Daejeon Court ordered the liquidation of a patent and trademark. The court also ordered confiscation of the stocks held by the Nippon Steel, which was established as a joint venture with the POSCO, which was appealed and dismissed last August. The appraisal process for the stock was completed early last year, led to order the sale of legally seized stocks at any time. However, the representative from the Nippon Steel has expressed their plans to hold up the sale process for the time being until further progression in the future. In the meantime, the 34th Civil Division of the Seoul Central District Court dismissed the damage compensation suit filed by 80 also the Korean forced labor victims against 16 Japanese companies last June. The gist of the ruling for dismissal seems to refer to the minority opinion of the 2018 Supreme Court in Brown ruling on the outset, but it has not been consistent with the legal principles and on the contrary include unnecessary consideration such as concerns raised in the compulsory execution process, which is unrelated to the judgment on the merit. Therefore, here is a need to observe the upcoming higher court judgment for overall interpretation of the law and legal principles. Rather, the ruling has summoned a long-standing debate about whether to view the interpretation of the Korean-Japan Claims Agreement from an international legal perspective or to regard the treaty as domestic law. Meanwhile, the Constitutional Court, the decision on military sexual slavery case, recognized that there was a dispute in the different interpretation of the agreement between Korea and Japan over whether the claims rights of the victims of the sexual slavery has effectively been extinguished by the Korea-Japan Claims Settlement Agreement 1965, and according to this dispute in interpretation, the omission of then government, the Ministry of Foreign Affairs and Trade at the time, which did not resolve the dispute in accordance with the procedures prescribed in Article 3 of the Claims Agreement, violates the constitutional provision to protect its citizens. Later on, the Constitutional Court has dismissed the suit seeking to rule on constitutionality of the 2015 Korea-Japan's Agreement on Comfort to Women Victims, the jointly announced by the Ministry of the Foreign Affairs of Korea and Japan for lack of constitutional complaints, reasoning that unless the right of the victims of the Japanese military sexual slavery would dispose of this through the unanimous decision of the courts, or the Korean government's diplomatic protection authority has expired, the 2015 agreement cannot be considered to have infringed on the legal status of victims and their basic rights, including the right to claim compensation. Meanwhile, the 34th Civil Division of the Seoul Central District Court ruled in favor of the plaintiffs in the suit by victims of the military sexual slavery against Japan by non-recognition state immunity, while the 15th Civil Division dismissed the same suit on the basis of the state immunity. After rendering of inconsistent judgment, questions were raised regarding the judicial decisions which also spurred the discussion of taking the military sexual slavery case to the International Court of Justice. After the Korean independence, the laudable compensation for victims of forced labor has become an issue, and the government of Korea and Japan continue to discuss normalization of relations and the post-war compensation from the end of the 1952. Finally, the June 22, 1965, the Treaty on Basic Relations between Republic of Korea and Japan for normalization of diplomatic relations and agreements on economic development and the cooperation resolution of the property and claims between the Korea and Japan was signed as one of the subsidiary agreements. Through the Korea-Japan Claims Agreement, it was confirmed that the compensation claim issues were completely and finally resolved at the same time, that Japan decided to furnish $300 million free of charge and $200 million the loan to Korea over the period of 10 years. According to minutes of the agreement prepared in the process of the agreement, the scope of Korea's summary of claims against Japan included the claims for reimbursements of the account receivable, compensation, and claims by Korean persons against Japanese persons or the Japanese corporations. In other words, the Korean government negotiated with Japan by including compensation for victims of forced labor as a subject of claims agreements, and the Japanese government has argued that all claims of victims of forced labor were extinguished through the claims agreements. Moreover, the Japanese military, the sexual slavery issues, which were not even publicly discussed under the predominant authoritarian and patriarchal system of the time, was no exception. If above is the case, is there no resolution to the forced labor and military sexual slavery issues derived from the Japanese colonial era? The legal principles of international law is changing and developing according to the interpretation of treaties. In the end, such a task at hand is for society to resolve through the agreement. However, undeniable fact is that there are definite victims present today without being properly compensated for all this time. Before discussing legalities of individual claims being extinguished under the treaties signed between two states, the reasons why individuals did not have to exercise their claims individually in numerous international treaties signed throughout the world, or to put more precisely, did not see the need to do so, was because their states went before them to actively seek compensation and endeavors to resolve problems for those individuals. It cannot be denied that claims agreement was a product of an impetus and premature decision without necessary and thorough consideration at the national level, and failure to give due respect and neglect of the duty to make effort to fully compensate the victims for their damages from a perspective of national community are the fundamental cause of the current situation. The lack of reflection by the administration dereliction of their duty and judiciary's ignorance was wrong then and wrong now. The confusion caused by the judiciary lack of awareness of international law in the government-led lump sum settlement is still reproduced and expanded today. The extinguishing of individual claims rights by the lump sum settlement agreement is not an exception under international law in solving complex claims issues between states, and is considering the fact discussed in detail. In a process of the signing the claims agreement, it is reasonable in light of the international law. Apart from the recognition of the legitimacy of the 1910 Korea-Japan's Annexation Treaty, it is difficult to accept the claim that claims agreement concluded without reaching an agreement on the nature of Japan's control of the Korean Peninsula does not include the right to claim damages for illegal acts directly related to the Japan's colonial rule, as emphasized by the Supreme Court ruling in 2018. Ultimately, the solution to the complex Japanese forced labor and military sexual slavery cases consists of securing historical and moral superiority through exercise of the subrogation and the right to indemnity as a nation. In other words, the government of Korea should express their sincere apology to the victims for their past mistake of insufficient representation and reflection on behalf of the victims from the illegal and anti-humanistic crimes derived from the Japan's colonial era in a process of the normalizing diplomatic relations and the sign of the claims settlement agreement with Japan. The second, on the premise of the continuous negotiation with Japan on legal issues evolved from the anti-humanistic crimes derived from the Japan's colonial era, the Korean government should implement measures to preemptively compensate the victims through legislative act enacted by special laws. The third, substantially pay due respect and honor the victims of the anti-humanistic crimes derived from the Japan's colonial era, develop and implement various policy measures, both domestic and international level, that allow the national and international communities to share as lessons of historical view from a post-colonial perspective. The belated apology by the government for their stubborn dereliction of duties and judiciary ignorance of international law call for what was wrong then but is right now, the government-led proactive solution. Thank you very much for your attention.